Hi. How you doing, Nate? Yeah, I'm not too happy. That's why I summoned you. Did you hear me? In my portal? I summoned you. Now, what do I always say? Did you get your book? I'm still gathering. No one can stop me from gathering. And let me show you something else. Shh, don't say anything. Look what I can do. Don't tell them. Shh, not at all. Nothing. So I'm not too happy with what happened in court. That bitch, Linda Blake. You know, I'm coming for her. Yeah. And I'm gonna summons Melanie Gibb, David Warwick. Hell, I'm even gonna call on Adam. The only brother I got left. Because poor Alex. Poor Alex. Who thought that was gonna happen? Not me. Not me. So I want to show you something. Somebody sent me a special gift because I taught her how to lie, try to fool the government, tell stories. So she sent me something. Want to see? Okay. Cheez-Its. Can you guess where I got them? Carly Russell. Well, yeah, I talked to her on my tablet. I said, hey, girl, go down the freeway, call and say something about a little kid. There you go. Well, she came through the tunnel to Idaho. Yeah. And look at special kind she got me. Pepper Jack. So, what do you want to talk about? They're gonna get me with time served. I ain't gonna get life. You crazy? Because I'm the queen of the Hunt 444.
Case law or statutory language that makes the appointment of a designated representative mutually exclusive, and I do think this is probably the case of first impression in Idaho. I am going to deny the motion and allow that Vicki Hoban's statement may be considered as a victim impact statement. Not that she's the victim, but she is the designated appointed representative of Tammy Daybell's mother, who is now deceased. And so, in the absence of any other authority that's been cited to the court or any statutory language, I don't believe it's error to permit that statement to be made. I will, however, leave it up to the discretion, of course, of the prosecution as to whether or not you think she should make any further comment or statement at the sentencing hearing, or whether the court would consider the addendum to the PSI, which was submitted as a written statement, which I do consider to be permissible given this analysis. So the ruling is I am going to deny the motion and will permit her as a designated representative to provide a statement in support of sentencing. That'll be the
Tammy's mother by claiming to be a victim and wanting to be heard by the court as a victim. I don't think the law allows that. I think the law specifically excludes aunt. And so if Tammy Daybell had no one speaking on her family's behalf, I think the court's current order would be appropriate.
Because I had nothing to do with it.
Tammy's sister and father have now spoken, and Tammy Daybell's father specifically stating, I'm writing on behalf of myself and my now deceased wife. I think that there's no provision for the court to consider an aunt as a victim able to speak on behalf of the Tammy Daybell family.
The only victim is me.
So I know she's interested in the case. I don't know her personally. I don't have anything against her. I'm merely
I do.
asserting the law, and the law, I believe, does not allow this. So I'd ask the court to reconsider or amend its order prohibiting the victim impact statement from Vicki Hoban. I see that after I filed this motion, we actually received her statement, though it is now submitted to the court and would need to be stricken. I don't have anything else.
All right, thank you, Mr. Archibald. Ms. Blake, what's the response from the state on the motion?
What's that bitch doing here?
Thank you, Your Honor. The state does recognize that anytime we're dealing with victims'
They
rights,
can hear me?
oftentimes there
I'm
are
not
some unique
muted?
issues that come up because we have a statute, we have the Constitution, but they're ever evolving and being interpreted by the higher courts. We also recognize this court has turned to an Idaho court decision to assist in making a determination as to who should be considered victims with regard to a homicide. I think some of this has been a matter of first impression for the court. There are several victims that had wanted to make a victim impact statement. I think the court went through an analysis in determining who would be able to and who wouldn't be able to. So the state recognizes that there are some individuals that would consider themselves victims that have not been allowed to make a statement. I think there are a lot of interested parties in this case, a lot of individuals that have suffered some form of harm, in whatever form that may be, from the acts that occurred in this case.
Nothing.
With regard to this particular motion, I think the state is really without a
I'm
legal basis
innocent.
to make any kind of an objection or argument one way or the other. So on this issue, we will simply leave it to the court's discretion while we recognize that this is a somewhat a matter of first impression to at least some degree. We'll leave it to the court's discretion for that determination.
All right, so to clarify, Ms. Blake, you're not stipulating to me granting the motion, is that correct? You're just arguing that you don't believe you have grounds to object to it, or I guess I do want to further kind of pin you down on the state's position here, whether it's a stipulation that the motion should be granted or just simply leaving it to the court's discretion. Let me sort it out.
Yes, Your Honor, the state would not be stipulating. I think we're in that unique situation where the state does not technically represent the victims in the case any more so than as part of the general public for our representation. So we're always in a little bit of a precarious situation when it does come to victims' rights and what positions the state can take, what arguments we can make. But as far as the motion brought by Mr. Archibald, I don't think there's a legal basis for the state to make any kind of an objection. So we're not stipulating to it. We're simply leaving it in the court's discretion.
All right, I appreciate your argument then. Mr. Archibald, would you like to offer any rebuttal argument?
No, Your Honor.
All right. I've been researching the issue, obviously, for some time in this case since it came up. The court, as it notes, is constrained in some ways through the Idaho case law, as well as the Article 1, Section 22 of the Idaho Constitution and the Victims' Rights Statute under Idaho Code 5306. And in this case, the court received a request initially, I believe coming through, not necessarily from the state, but through the prosecutor's office of a individual indicating they wish to make an impact statement, Vicki Hoban. And the court went through an analysis and entered an order allowing for her to give a statement. The court initially was under the impression that there were not going to be any statements made on behalf of the deceased victim in this case, Tamara Daybell.
Had nothing to do with
at
it.
this point, there are apparently family members that qualify,
I don't
including
know
her sister,
them.
Samantha Williams, and her father, Ron Douglas, who will make statements. So then the question becomes whether or not that changes the rationale or whether the court would permit or allow Vicki Hoban to make an impact statement. As an initial point, I would indicate that by making these rulings and determinations, the court has never tried to minimize or not understand how far-reaching the impact can be in a murder case for family members, friends, associates, others that knew victims of this particular crime. Idaho does, however, have limitations on who's permitted the rights under the Victim Rights Statute and the Constitution because they essentially get some privileges that wouldn't otherwise be afforded to normal people without those privileges, such as being able to make a statement without being required to be placed under oath or cross-examined on the statement. The court would note there's a policy behind allowing victims to be heard. One case that the court considered is a case called State versus Leon, 142 Idaho 705, and the issue is a little bit different there, talking about whether or not a DVD or video presentation was permissible as part of a victim impact statement. And really the focus in that case was on what it means to be heard. Under Idaho Code 195306E, the court, the victim statute does indicate the term heard. The victim has a right to be heard. So I'll note that this is just by analogy, but some of the language in that talks about, in that case, the victim's right to be heard conforms with the discretion traditionally afforded a trial court to consider a wide range of information at sentencing. It says it's fundamental that a sentencing court may properly conduct an inquiry broad in scope, largely unlimited, either as to the kind of information it may consider or the source from which it may come. And that cites a case of Payne versus Tennessee and also Matson 123 Idaho 625. This is the State Leon case. Further goes on to state.
Hey, Nate. Thanks for coming at the last minute. Appreciate it. What happened? I got into a fight after court. She pulled my hair on both sides. And she poked me in my eye. Yeah. Hey, I'll show you. Don't laugh. It hurts. You ruined my hair. So I was upset. And did you notice? Guess who didn't speak during the hearing? Probably. You know why, don't you? That bitch Linda. Linda Blank. Can't stand her. Did you get your book? Because I'm still a Gatorade. So, you know, I'm not going to serve no more time. Yeah. How do I know? Because the prophet told me. He told me that he went and got in the judge's hat and rewired things, and you know, see my queen. 444. Do I still got them? I'll show you. I still got my Cheez-Its. I'm not sharing my Cheez-Its because we can't get this in canteen, and you can't tell anybody I got it. Why? Because Carly came through the tunnel all the way to Idaho. Because we don't have Cheez-Its.